Hi, and thanks for reaching out to Cognition IP. Since 2018, we've drafted, filed, prosecuted, and managed valuable IP assets on time and on budget for hundreds of fast-growing tech companies. For the sake of answering some common preliminary questions, we've recorded this video with a Q&A transcript below to help you get started. Please note, while we can share some general answers, we take each client's factors into consideration for a tailored strategy, focusing on efficiency, timeliness, and the results that suit your legal and business objectives. If the following is a match for your expectations, we invite you to a complimentary consultation. About Cognition IP, our firm was founded in 2018 by our tech and legal co-founders through the Y Combinator accelerator, with a vision of building an efficient, tech-powered law firm that solved some common problems in the traditional legal marketplace. By leveraging operational tech and the expertise of our IP attorneys, we've developed a business model to deliver top-tier IP results with one-to-one attorney support on competitive fixed fees. As a firm, we use Fortune 5 best practices for IP drafting, filing, prosecution, and portfolio management, with results competitive to top 20 firms. We have grown steadily from the positive word of mouth of our clients, the network at Y Combinator, and the greater San Francisco and Silicon Valley-based tech communities. We serve startups, scale-ups, and enterprise as on-demand, optimized outside IP counsel. When is the right time to think about patents? The USPTO is a first-to-file system, so protecting your innovation as early as possible is usually recommended. Pre-MVP is good timing for planning an early evaluation. At MVP, a provisional application can secure your filing date while you continue building. On the topic of timing, a note of caution. Disclosing even partial invention details in a public launch, on your website, or in public presentations can block patentability in some countries, so please be aware there are risks to a commercialize first approach. What technologies are you known for? Our team of attorneys each have 15 plus years of experience at prestigious law firms and enterprises, creating and protecting IP with extraordinary amounts at stake. Their expertise is with a wide range of technologies as listed below. Our fees. We work on competitive, cost-effective, transparent fixed fees almost entirely off the hourly attorney fee model, unless custom work requires it. With this approach, our clients can budget accurately and without legal bill surprises. It might be nice to know that we do not charge for standard communications. As well, we will look for opportunities to maximize the value of your IP strategy with your given budget, but we do not sacrifice quality in the process. Please inquire for our standard fixed fee quote. USPTO fees are paid separately. How are provisional applications handled? We draft provisionals with the same care as non-provisionals. Our focus is a fully enabled application which adequately prepares for the non-provisional conversion in due time. We do not recommend or facilitate DIY or shortcut approaches. We believe in a thorough foundation for your IP, which includes a well-crafted provisional, even if it is broad. We do not recommend a provisional for all clients, as it has strategic benefits primarily for pre-MVP or MVP stage innovations. When do I have patent protection? Filed provisional and non-provisional applications do not provide legal protection. You may use the term patent pending after filing, which is simply a notice to competitors that an application has been filed. It may provide a general barrier to entry from a marketing perspective. Upon meeting the USPTO requirements and completing the patent process, an approved patent would provide legal protection. What are your USPTO approval or success averages? Approvals cannot be guaranteed. However, our firm has a very high approval rate, averaging 90% for applications we file and draft, with low average office actions, low average RCEs, high success with difficult examiners, and speedy pendency averages, all of which are competitive with top 20 firms in the US. Do I need a patent search before filing? We do not perform patent searches in all cases. Patent searches, which may typically cost between 3 and 5,000, are never absolutely conclusive. Directing those funds towards the first office action might be a better use of budget in certain circumstances. We do offer patent search, landscape, and full freedom to operate only when there is a strategic benefit. General patentability can be assessed in the early discussions with your attorney. What is the process and timeline? If you've allocated a budget towards IP and are ready for evaluation, we invite you to a brief discovery call to see if we could be a good fit on technology and timelines. Should we both decide to move forward, we would share an engagement agreement. Upon signing, we can begin the process and issue a disclosure form. After your disclosure form is completed and returned, we will review the technology. If we both agree on proceeding with services, we request payment upfront. Our typical timeline is 4 to 6 weeks from the point of engagement for most services. Average USPTO timelines can be 2 to 3 years for patents or 1 to 1.5 years for trademark, both of which can be shortened considerably with a fast track option. Why choose Cognition IP over other firms? We offer a unique combination of transparent, fixed fees, specialized expertise for tech startups, scale-ups, and enterprise, customized strategy, one-to-one attorney support, and a strong record of efficiency. Do you accept equity or payment plans? We do not. Drafting and filing fees are expected before work begins. Other service or procedural fees are billed as they occur. USPTO fees are paid separately. How do I get started? Book a complimentary discovery call with our attorneys to discuss your invention, strategy, and next steps below. Thank you.